Hi, hello to all of our wonderful friends right here in the United States of America and to everybody else tuned in from different parts of the globe who are interested and who would like to join the immigration conversation. Welcome. My name is Mary of Silmi Law. And of course, let's welcome the amazing, the one and only rock star attorney, not according to me, according to our Google reviews, Attorney Sharif Silmi. Hi, Sharif.
Thank you. Hi, Mary. How are you?
I'm doing great.
Good, good. So nice to see you. I
Thank
think
you.
I thought I saw somebody with you there.
Yeah, it's my dog puppy. Hi, say hi, Muffin.
Wow. Hey,
Say hi.
Muffin.
She's been with us since I got my green card. So
Oh,
she's
okay. Cool.
she's born
So
in
Muffin,
Missouri.
I hope Muffin will bring you lots more good luck and all of our clients and listeners out there as well.
Yes. I pray the same for everybody. So we are very grateful to Attorney Sharif for helping us kickstart our American dream. So Muffin has been to many different states already because life has been so good to us.
Oh, good.
Thanks to, of course, starting with our lawful immigration journey. So let's get started because so many people would like to learn more about our very interesting topic today. So basically, today we are going to talk about PERM and O1A. So today is all about maybe first understanding what PERM and O1A is all about and which route should I take. So maybe
Yeah.
Attorney Sharif, we can start with you giving everybody maybe a high level overview of what PERM is and what O1A is, especially for those who are just hearing these two terms for the first time.
Absolutely. And I think part of what we can kind of talk about or frame the conversation around is also that these are employer sponsored petitions, right? So I think last time we had a conversation, we were talking mostly about self petition scenarios. Here, whether we're talking about a PERM situation or an O1A, we're talking about employer sponsored petitions. So the first thing I think everybody needs to understand is that these are scenarios where an employer would actually be the person or be the organization that would sponsor the individual seeking to remain permanently in the United States. And they're very different. I mean, they're really, really different. So I think a lot of folks, need to understand that they are nonetheless tools that they could talk to their, maybe HR teams and their various companies. Or if it's like a closely held company, it might be an opportunity to kind of think about a more dynamic way to immigrate permanently to the U.S. because the O1A visa is interesting because it is a employer-sponsored petition for individuals with extraordinary ability. So for your like very highly skilled folks, it does give you a really nice pathway. And the great thing about it is that you don't have a huge long wait time in order to get approved. And also, you don't have to be subject to a lottery like you do, for example, with an H-1B. Whereas but it is very, very different from a PERM because we're talking about a non-immigrant, although it's a dual intent visa. So what that means is that an O1A is still non-immigrant in the sense that you will not get a green card directly from a O1A visa, but it does put you one step forward toward going for permanent residency. So you can kind of use it as a pathway to permanent residency, but it does not actually result in a green card. So that's one thing we need to understand about the O1A. On the other hand, PERM, we're talking about permanent labor certification. So what this means is that an employer is actually going to petition for an individual through the Department of Labor. So they don't actually go to the Department of Immigration or Homeland Security directly. Rather, they go to the Department of Labor and they are seeking to hire a foreign worker because they are not able to find a U.S. Authorized worker to fill a particular need, right? That is kind of the premise of the situation. So in a PERM scenario, you have a U.S. employer who will go to the Department of Labor seeking a certification to hire a foreign worker. And that will then start a chain of events that the employer must undertake in order to hire a foreign worker. That includes advertising for the job, providing a prevailing wage determination. So one thing the government wants to make sure of is that the foreign worker is not being sought out to lower wages, right? They want to make sure that the wages being paid are prevailing wages, that they are at least at the average or higher with respect to the kind of work that's being sought out. Usually this is kind of like a specialized area of employment. So there are generally two categories where PERM comes into play, and that is an EB3 scenario. So an EB3 scenario is usually a bachelor's degree individual who has some specialty knowledge. For example, they could be an engineer who, they have a bachelor's degree. Could be like an IT professional, for example, is a very popular one. And then you have an EB2 PERM, and that is for a professional class worker. So someone with a master's degree, for example, being hired to undertake some kind of work that would require maybe a greater or higher level of education. And there's also ways in which one can petition in an EB2 category under PERM, where their qualifications result from experience rather than additional education. So there are a number of ways in which, these things can change. But for the most part, the result of an EB2 PERM application or an EB3 PERM application will be the same. And that is ultimately it will result in a green card. But you have to go through a very, very long song and dance here, right? You have to start by going to Department of Labor. You have to advertise the job. You have to have a prevailing wage determination made. And then after all that is said and done, you have to go back and actually apply for the labor certificate. And then once that entire process is done, which in this, I guess day and age, maybe post-COVID and what have you, I guess we're still in COVID. During this whole, sort of time period, or in recent history, you can say, we're looking at a 2-year proposition before we're even going to Homeland Security to actually apply for the green card. So, and in those instances, you could do premium processing, which will allow a case to take place, within 15 business days. But then you're also applying for actual green card, which is an I-45 adjustment of status, which will probably take another year or so. So there are, again, various ways in which we can do this. If you are doing adjustment of status, it's going to add a lot of time versus consular processing, which is where you're coming from outside of the US. But ultimately, they're very, very different, but they're both tools that are available for employer-sponsored petitions. So that's either O1A through an employer-sponsored scenario, or PERM through employer-sponsored scenario, but resulting in a green card. They can be used. I think a lot of maybe highly skilled folks might think about an O1A because it gives them the instant ability to work in the United States, whereas PERM is going to take them a really long time. But the end result is, a green card, whereas the O1A, the end result is just your ability to work for a particular company.
Okay, so trying to follow that conversation, like it seems to me that like if I want to get a job right here right away, right? Maybe I should like find an employer who can support me through the O1A process. But then like going back to PERM, like hearing that even if like what you said, right, the whole dance and song, but in the end, I think it's worth it because you'll have a green card in hand. What would you advise the people who would still want to go through, let's say, an EB2 or EB3 PERM? Does it mean that I have to have an H1B in order for me to go through a PERM? I mean, what do you advise people who maybe don't have H1B status? Do they wait? I mean, do they wait for the process outside of the States, or what should they do?
I mean, that's the problem with PERM is that, look, you really are in a scenario where you have to wait a really long time for your benefit. And I think the way that the system is designed, like if we really, really want to think about like the immigration journey. So for example, somebody might come to the US as a student, right? And they're doing their, F1 student visa. Then they come into the US, they get an education. Then once you have an education, particularly if it's in a STEM related category, that's science, technology, engineering, or math, then you probably will be eligible for a longer OPT, which is a practical training. So that practical training period is a continuation of your student status. However, you get an employer authorization document. So what you do is you take that employment authorization document, and now you're able to get a job. So let's say you land a job. Well, what's next? Well, what's next is that if your employer likes you, they're going to sponsor you. So ideally, they sponsor you through an H-1B. But guess what? H-1B is subject to lottery. So then you don't have any certainty. So you can kind of start the PERM process, but then it's like a race. Will my PERM be done before my status expires? If not, you have to leave the US, because overstaying your status prior to, overstaying your status before being issued an I-45 or sponsored by a company will make your entire process you will not be able to immigrate because you have that overstay. If you have an employment-based situation, you overstay, then you're out of status. Worse yet, you are working without authorization for the company. Forget about it. You've probably just, doomed yourself. So you have to be really, really careful. And that's why it's important to work with an attorney while you're going through this process. I've actually seen people burnt because of reliance on their company. And I'm talking about sophisticated employers, right? University systems, big, massive corporations. You think that they're going to follow the proper procedures, but things fall between the cracks. And the individual was completely and totally dependent upon their employer, and it was all basically ended up turning against them. And I think so, folks need to really have their own independent counsel, even where you have an employer-sponsored situation. So, that's really, really critical. One thing I did want to mention is that companies that are out there and looking for talent, it's really, really important that they know about O1A. So many human resource departments or like people management folks, head of people at really great companies in the US do not even know about the O1A. And the O1A is an amazing tool to bring forward highly talented people. And you do not have the same wage requirements as an H-1B, for example. So someone who is, perhaps really high level talent in another country, maybe in India, for example, where they're coming out of a high level institution like IIT, which is the Indian Institute of Technology, someone of that caliber can certainly come to the US through an O1A path, right? Because that way they don't have to worry about the lottery pick in an H-1B, and they'll end up, being able to work at a company, and that company is benefiting in a very, very important way by having super high talented individual, and they don't even have to pay the prevailing wage, right? So that becomes a really, really important task, or an important way in which you can, have some very high talent people in the US.
Okay, so like two follow-up questions, Attorney Sharif. Like, if ever, example, my friend or I apply for an O1A, let's say, do I have to, stay with the company who sponsored me, and how long will that validity be for my O1A visa? And second, I hope you find it interesting. Like, let's say I think I'm highly talented, right? I listen to Sharif, Silmi, and I'm convinced I'm of extraordinary ability.
You are extremely talented, Mary. There's no doubt about it. You're the best.
Thank you, but you already helped me.
I know you're being hypothetical, but go ahead.
So, yeah, I've watched your videos and I could qualify for O1A, but why shouldn't I go for EB1A? Because it both says extraordinary.
Well, okay, let me take the first question, the former. So in terms of an O1A, it's generally good for 3 years for the initial period, and it can be renewed. You can continuously renew the O1A. Now remember, the O1A is a dual intent visa. So you can enter the US on an O1A with the intent to find a pathway towards immigration. So although it does not directly result in a green card, it does give you a pathway, right? So that's one point. The other thing is, once you have an O1A approved, you can basically count on it continuously being approved, because you've already established that you meet the criteria. So a subsequent O1A petition, perhaps by a different employer, would have the same result. Otherwise, the adjudicator would have to really explain why they are, contradicting the previously approved decision. So it's highly unlikely that an individual has an O1A approved and then has a subsequent O1A application denied. All right. So what that means is, like, you come in through one company, you might be on a 3-year O1A, 2 years down the line, you get a job offer, then you can kind of transfer your O1A. We call it a transfer, but in reality, it's a new application that's being, made by the subsequent employer, and it will be approved based on the previous approval. You still have to provide the package and the documentation, but you don't necessarily have to, reinvent the wheel. Okay. So let's just put that on the side. Now, I think the second question you had is, if you're a super talented individual, why are you going for an O1A and not straight for an EB1A? The reason why you might go for an O1A is that it's one step along the path toward an EB1A. And it's less, I would say, less scrutinized, put it that way. There's less level of scrutiny with an O1A than there is an EB1A. And then there's some minor differences as far as the statute. So, for example, with the O1A, you must establish that you are performing in an essential role for an organization, or that you have performed in an essential role for an organization that has a distinguished reputation. Whereas with an EB1A, you have to demonstrate that you perform in a critical role or a leading role for an organization. So demonstrating that one is essential is a little bit, I think, easier than demonstrating critical or leading. The other thing is, earlier this year, the Department of Homeland Security, USCIS, issued policy regarding O1A, and it basically provided very detailed examples that relate to STEM-related applicants. So those of you who are in science, technology, engineering, math, and you have a pretty good, track record in terms of accomplishments, there's a very clear pathway through O1A now. That did not previously exist. It was kind of just like it was a free for all, and you just kind of had to interpret the law according to, what suited your interest. But now for STEM folks, there are very, very specific examples that the government provides in the adjudication guidelines that would, probably allow a vast majority of folks, who are talented and in these STEM categories to qualify. So, and then once you have an O1A, there is a, understanding, or, at least a presumption that you would qualify for EB1A. Meaning, once you have an O1A secure, and it's an easier thing to secure than an EB1A. I mean, we have, I would say, many hundreds of people who have had O1A approval that would not have gotten their EB1A approved. But once you have the O1A approved, then you apply for EB1A, largely based on the same evidence as your O1A, and you're more likely to have your EB1A approved, because there is a presumption in the adjudicator guidelines that states one who already qualified for an O1A will also qualify for an EB1A. Otherwise, the adjudicator must explain in their decision why they're diverting from the O1A approval. And what is it about the application that meets the O1A requirement but does not meet the EB1A requirement? So this makes a kind of more difficult decision, making process for the adjudicator, and ultimately, I think, results in them, being, better off to just approve the case and not have to deal with the headache of getting a nasty, letter or appeal from somebody like me.
And I think that's great news for some of our loyal clients, right, who continue to trust us. In fact, we just signed off a few of our O1A clients. A handful of them have already signed up for EB1A with us. So just to be clear, and to not keep their hopes up, were you saying that 100% their EB1A is going to be approved, or how
I
does
would
that work?
say, I mean, it depends. Every case, it depends, but it's not 100%, but it is very, very highly likely because there's a presumption. So a presumption means that the adjudicator must presume that it is approvable
Mm-hmm.
unless they see otherwise. So they would have to explain why they're not approving it. And there's specific language in the adjudicator guidelines that states where an applicant has already been approved for an O1A and they subsequently apply for EB1A, and that case is being denied by the officer. There needs to be a thorough explanation provided explaining why they are diverting from the O1A approval. So
Okay.
that creates, it kind of shifts the burden. So that
Mm-hmm.
normally in any immigration administrative review, the burden of proof is on the petitioner, is on the person applying, right? But where you already have an approved O1A and one is applying for EB1A, it kind of shifts the burden to the government to say, well, we're not going to approve it, and here's why.
Okay, that's
All right.
understandable. And so far, many of our clients, as mentioned, right, they go from O1A after we filed them a successful O1A, they go straight to EB1A. But just to ask, like NIW, would you ever advise O1A to NIW, or it's wiser to do it O1A to EB1A?
No, you could absolutely. I mean, the thing about an NIW is that you're going to have other factors that come into play. That I'd say the main difference is this: is that an NIW is a waiver from PERM, right? So we explained what PERM is, right? Uh, Now the NIW is saying we want to waive that PERM process. An EB1A is not saying that we want to waive the PERM process. So a person who is going into a scenario where they're in a like normal employment, like a corporate type job, maybe a high level managerial job in a company, they're not necessarily the ideal NIW candidate, because the question that the government's going to have is, why don't you just get your employer, right? You have an employer, that employer can submit PERM. Why don't they just do it? Why are you going through national interest waiver? That question does not arise with EB1A. With EB1A, the question is just, do you qualify or not, right? So I think that in those instances, EB1A might be a better path for someone who, is already qualifying for an O1A.
Okay, so yeah, I think the
If
the
they're an
buzzer.
entrepreneur, if they are, working for an organization that, as a matter of policy, does not sponsor foreign workers, if they're maybe working in a nonprofit space, something like that, then sure, there could be a easier path through national interest waiver.
Okay, so like now another question, attorney. You know what? Like many of our clients, right? Most of our clients, their feedback would be, they trust you because your insights are different, and they'd be amazed after some would consult with other attorneys. And one of the, I think the common feedback that I'd get was that, oh, Sharif told me that I could never adjust status if I was out of status, right? Previously, like many other attorneys, I don't know if they were really even attorneys, right? Who consulted with them, they were willing to take on their cases for even an EB1A, right? But then they appreciate you because apart from knowing really right your field very well, it was your insight, being clear that if you're not in status, you don't have a status, then I will not be able to help you adjust, right? Or you'll have to do consular processing. So what some of our clients would like to know is there really no hope? For example, I'm out of status for, let's say, 3 months, right? And then I didn't tell you, right? And you file for an NIW or an EB1A or an O1A, and I get approved. Is there really no hope? Is it really against the law, and the firm cannot do anything about it?
No,
If
we
the
can. I mean, it does become a lot more difficult. I think we had a case recently where a person was out of status for even more than a year, and we were able to adjust their status. And that was largely because we were able to demonstrate it was through no fault of their own. So remember at the outset, I was kind of explaining how you cannot depend on your employer. So I actually had a scenario where an individual was working for a state agency, right?
Mhm.
They're actually in a government paid job, and somehow the HRs, whoever, they dropped the ball. They did not renew the paperwork for the individual. And not only was he out of status for almost a year, but he was working without authorization. So it's
Oh
like
wow.
remember,
That's
what was that show? Double whammy, right? Double whammy. This was a double whammy, right?
Mhm.
Pressed your luck. That's what it was called.
Mhm.
So, double whammy. And, we were able to overcome it. So there are ways in which you can overcome it through argument, through, various channels and means. And not everything is straightforward. I think too many times I've heard people say, oh, so and so is in this scenario, and they ended up overstaying, and then they couldn't do anything about it, and they had to leave the country. So that means I'm booking the next flight and I'm leaving the country. Hold on, wait a minute, consult with an attorney. Let's figure out the scenario. Let's see if there's anything we can do about it, because that's not always the case. I mean, you sure as hell do not want to go out of status, right? And you definitely don't want to go more than 6 months out of status. You
Mhm.
absolutely must not go a year out of status. I mean, yes,
Yeah.
I totally agree. Do not get yourself in those situations. But if you're
Mhm.
already in the situation, right, don't make any further moves that will make your situation worse.
Harder
So
and harder. Yeah.
absolutely. Yeah. So I mean, I guess the answer to your question is, look, somebody who's in status and thinks to themselves, oh, well, it doesn't really matter. I can overstay a little bit and then I can do adjustment of status. I heard it's not a big deal as long as it's less than 180 days. I think they're being very foolish, right?
Mhm.
Now, it doesn't mean that one who is already overstayed cannot solve the problem. But my
Mhm.
advice is don't create the problem in the first place.
Yeah, that is so true. And like one of the most important things, right? If you guys are listening, you'd realize, oh my God, there are so many like, moving parts. There are so many things to think about, so many things to write and jot down. So I think the best advice that we can give you is to first consult, right, with an attorney, someone as knowledgeable and compassionate like Attorney Sharif Silmi. Yes, so I think many people are getting more and more interested. In fact, there's so many questions, right? There's so many branches of questions that we can ask right now. Just now, in
Yeah, I
terms of
just wanted
a
to
while ago.
address one of the questions online, and the individual is mentioning that there was whether they can apply for an H-1B with a 3 years bachelor's degree. So the answer is get your degree evaluated, right? So once you have an evaluation made, and if you email us, we could kind of point you in the right direction in terms of evaluation. Then you can determine whether you would qualify for an H-1B. And also remember, any H-1B individual, you need a sponsor. You need an employer to sponsor your H-1B application.
And then now, in terms of the profile, Attorney Sharif, in terms of a profile, what for you, like just offhand, right? Even before you consult, do a deep dive. For you, what makes a strong O1A candidate versus a strong PERM candidate? We already know that both need to have a sponsor, right? Somebody who will support them in the petition. But like example, I insist I want to go through a PERM, even if it's longer, because I want to have a green card in hand, right? What would make you sway the person and say that O1A maybe is better, even if it's not it's just a step towards a green card.
Well, I think a lot of it depends on the employer. And in some instances, you might even want to do both, right? Particularly if you don't have an H-1B visa, because the PERM is what's going to get you the ultimate, result of having a green card. And in the meantime, if you need to work and you don't have any other status that allows you to work, for example, a lot of folks come to us and they're dependent on their spouse's visa. So let's say your spouse is a student and you're on an F2 visa, but you're a super highly talented individual and you have not yet found any particular area. Then we should definitely think about the pathway through an O1A, right? And by the way, lots of entrepreneurs can benefit through an O1A. So like you can, even if you're in an H-1B, you may not have to, you definitely cannot work for a company besides the company that's holding your H-1B visa. But it doesn't mean you cannot own a company, right? So you can own a company, you can be a shareholder, even the only shareholder of a company, but you cannot be employed by that company unless that company sponsors you. And guess what? They could sponsor you through an O1A, right? So that's an amazing way to do it. And I see one of my buddies here. Hi, Sharif Kalpesh. Hey, buddy, how are you? Nice to see you. So one of our many successful clients there, wishing us well. So that's nice to see.
Hi, Kapesh. Yeah, that made me very excited and happy for my friends because, like many of my friends, I mean, they're professionals from the Philippines, right? But
Mhm,
all they know about emigrating to the United States are B1, B2, and fiance visa. That's it.
mhm.
I mean, it's a
Yeah,
shame that
it's a shame.
not a
The
lot of people.
information's not out there.
Yeah. Like even like way back, that's all I knew. B1, B2, and fiance visa, and that's it, right? But we're very grateful for people like Attorney Sharif, right? Advocates of immigration, right? It can be quite elaborate. You read a lot of people, right? Saying that it's very distressing. And it's an
And you know,
emotional.
just to kind of chime in for a second about Philippines, if you think about the Philippines, you have a huge advantage because there's a lot of English language proficiency in the Philippines, and a
Mhm.
lot of so there is some level of bias. I mean, like statutorily, it should not be the case that one whose achievements are in another language have like a less hopeful pathway towards immigration. But reality is, that there is some bias, right?
Yeah.
So those of our Filipino friends, they should think about, like, if they have businesses or they have made achievements or things of that nature. A lot of it is documented in already documented in the English language, and that's a huge advantage, I think, when it comes to immigration. I think we tend to have some bias against, for example, Chinese language materials, or maybe Urdu language materials not being up to snuff according to certain adjudicators, where while I disagree with their interpretation, at the end of the day, we're just looking for the results. So you have to make sure that we're able to progress in a beneficial manner. So that's something that we should probably look at.
Okay. Yeah, and that's hardening for many of our viewers. So I have a one of our clients said my cousin has a okay. One last question, Attorney Sharif, before we go. So
Sure.
one last question is my cousin has an LLC. Can she sponsor? Okay. So I think the question is, can anybody just sponsor? Let's say I have an LLC, but I mean I guess the question is like I'll just come up with an LLC and sponsor people. I don't think that's a good idea, but
Well,
that's
I mean, it
immigration.
depends. I mean, if so, they're saying an LLC. So an LLC is a kind of business entity, right? So you have that's a limited liability company. You can also have a corporation, right? A corporate. So the difference between an LLC and a corporation is that an LLC is like a member-based. It could even be a single member-based entity, and then you have a corporation. So a corporation is one where you have a board of directors, and then you have shareholders. So there's kind of differences in the business structure. I like LLCs because they're flexible. You could kind of make your own bylaws and your own rules, whereas normally corporations, they're like statutorily mandated to act in a certain way. For example, you have to have a shareholder meeting at a particular time, or you have to have certain disclosures or things like that. Whereas an LLC, you create your own bylaws. All right. So just understand what an LLC is. So now let's say, for example, an LLC has been formed, or an LLC exists. So
Mhm.
that LLC should exist for some kind of business purpose, right? So maybe it has some technology, intellectual property. Maybe it has it has some plan of, commerce, right? It's
Mhm.
going to engage in some economic activity.
Mhm.
Now, a person who's not authorized to work cannot drive that process, right? However,
Mm.
they can own that company, all right?
Okay.
And that
Mhm.
company can hire folks who are authorized to work, right? So
Okay.
if that company hires somebody, so they hire Sharif. Sharif is driving the business. I'm the, whatever, sales agent for the company selling its technology. The owner, right? The whoever the owner is out there, they can say, "Hey, this company is starting to grow. I think I need to intervene. It's more than I thought it was. I thought I was just going to be a passive owner. Now, you know what? I think I'm going to use this company, right, to be my bread and butter. So I need to get in there and, drive the growth of the company. The company can sponsor the owner, all right? If they qualify. independently based on their own profile, right? That's completely and totally allowed under the immigration laws.
Okay.
All right.
Yeah, so I think we've had a very, very meaningful discussion today. So, to all of our wonderful friends who are watching and who still have a lot of questions, please do email us at info@silmilaw.com. So, I think we'll be seeing you in our next video. So, please do
Yeah, I
subscribe.
look forward to it. We'll have more of these conversations. Hello, Amit. Hello, Kavya. I hope everybody out there is doing well. And thank you, Mary, for the conversation. As always, I know we had a little bit short, but we have a lot of work to get to because people are, definitely needing help.
People are calling, yeah,
So
yeah, and following up.
we
Yeah.
will be back.
All right. Thank you. Have a good day. Thank you, Sharif. Bye
Thank
bye.
you. Take care.